SJC-13217, Commonwealth versus Joshua Hart.
Good morning, Stephen Maidman for Joshua Hart. This case involves jury instructions for attempted murder. And the result of the case, the verdicts are legally inconsistent. They cannot be reconciled. This was not identified in the trial court. The judge didn't realize it. Neither the parties realized it. It was picked up by this court, and that's why we're here today. And I want to be very careful how I articulate this because it can be confusing. And let me just add, these were under, the court used the model homicide instructions that were in effect at the time. They had been modified. And the judge did not pick up on that. The defendant didn't pick up on that. The Commonwealth didn't pick up on it. And that's why we're here today. The jury was instructed with respect to attempted murder that an element of the crime of attempted murder is that the crime was not completed.
No, actually, what it said was, and this is really important, it said that the act of the defendant did not complete the crime. And it's not that the defendant did not complete the crime. It's that the act of the defendant did not complete the crime. So can you explain how this is actually legally inconsistent, where there was testimony and, in fact, two different indictments reflecting that multiple acts of the defendant were at issue?
Well, there are lots of multiple acts in this case. The way the indictment came down was before she passed. And let me just say, they're terrible facts. I'm first to suggest that to the court. She didn't die. The defendant, at least at the time that he was indicted for attempted murder. But the record shows that he admitted to the state police there was a series of acts. And I would suggest to you that this was a single criminal transaction. You can't slice and dice this to make it was this act, it was this act, it was this act, it was this act. Temporally, they were probably all they certainly at the same time, same place. And this thing probably happened very quickly. So for the Commonwealth to come back, and I understand their position is that he was indicted for smothering and slicing her throat. It wasn't slicing, it was basically slicing the neck, and that's in the record. And the jury could have convicted him based on that. They could have convicted him on any of these things. And it's pure speculation what he was convicted, what were the separate and distinct acts.
Doesn't the language of the indictments bear on this question?
Sure, but again, the indictment was not a jury instruction. In this case, the trial judge gave the standard jury instruction that indictments are used to bring the defendant before the court. Now, I think it's fair to say that the indictment went in attached to the verdict slip, but this jury was never instructed on separate. You can find separate and distinct acts to convict him of attempted murder. They were not instructed.
But they were on notice. What the Commonwealth contended were the acts underlying each indictment.
Well, certainly the indictment says what it says. Mm-hmm. Okay, but in terms of the jury, certainly wasn't on notice on that. There's nothing in the record suggests that. Certainly the indictment says what it says. Okay, but the jury was not instructed that you could find the separate and distinct acts to convict him of this crime as opposed to murder. The jury was basically told it was was the acts reasonably close to the completed crime. At least that was the instructions were very brief, and I would also point out that in the Commonwealth's closing argument, there was nothing about separate and distinct acts.
Didn't the Commonwealth specifically argue different acts for each crime that tracked the indictment? There was
No.
I thought that the prosecutor specifically said first he attempted to suffocate her, and then when that did not work, et cetera. Sorry, I don't have the exact page.
I have it here somewhere. That was Attorney Busey's closing. It's on page 81 of the transcript. He said, and then he left Joanna Fisher to die, disabling phones, knowing that she was bleeding a lot, knowing that she was stabbed, after attempting with his own body to kill her by standing on her chest and breaking her ribs and putting a pillow over her face. This is premeditation. He brought this up in the context of, was it a premeditated crime? It was not in the context of, this is attempted murder, this is murder.
Well, you just used the word attempting. You just used the word attempting
Yes,
when you were summarizing what he said, attempting to. Does that support the separation a little bit?
No, I don't, well, I certainly, the way I meant to say it, the way I
You just were
intended.
quoting it, right? You were quoting it, right?
Yes,
Yeah.
he didn't use the word attempted anywhere in this sentence.
Didn't you just read attempting?
Yeah, you're correct. After attempting with his own body to kill her by standing on her chest and breaking her ribs and putting a pillow over her face. Yes, I did read that. I'm sorry. But
So does that support what Justice Dewar was saying, that there was this kind of separate? And by the way, remind me, the co-defendant starts out, how does she attack the woman victim?
well, that's not entirely clear based on this record anyway. There were two different trials. I mean, the way it started out, at least in my reading and my recollection, was she knocked her out of her wheelchair. That's my recollection of it. But this was a absolute joint venture. There's no dispute about that. The question is, could the jury come back with two different verdicts? One where essentially he didn't murder her, and then where he murdered her. There's a problem with that. Certainly from a I don't want to use the word common sense. Maybe that's too strong. But certainly one can reasonably question whether, how could you say he didn't complete the crime and then say he completed the crime? And that's why this falls into the category of legally inconsistent verdicts. I don't think these can be reconciled.
How do we factor in the fact that the defendant would be the beneficiary of a jury instruction he didn't deserve?
Jury instruction he didn't deserve.
He got more than he should have gotten. And that's the basis of the inconsistent verdicts, right?
Well, that's the way the jury was instructed. That's what the judge told the jury, to use these instructions to find attempted murder versus murder.
Right, and we assume the jury followed that instruction.
One can reasonably conclude that.
Well, that's our law is that we presume that the jury followed the instructions. So if we make that presumption,
that's why
doesn't that defeat your argument that the verdicts are inconsistent?
No, I think it buttresses the argument that they're irreconcilable.
No, because I think, unless I have it backwards, in order to find him guilty of attempt,
Yes.
they would have had to find that the act of the defendant did not cause the murder.
Yes.
And to find him guilty on the murder, they would have had to find the opposite. So they would not be inconsistent.
No, they are inconsistent. One is when they found him guilty of completing the act, and then they find him guilty of not completing the act.
Well, as long as those two convictions rest on separate acts, then they're not inconsistent.
Well, that's why this is a challenging case. The issue of whether they're separate and distinct acts. My brief, I went through each of the witnesses who conceivably could have separate and distinct, could articulate separate and distinct acts. The medical examiner said that that essentially she died of the stab wounds, and she was she never returned to her baseline condition.
So again, doesn't that support a separating the pillow from the knife and the attempt from the murder? I'm not saying, I understand as a practical matter, these are connecting activities and they're happening close in time, but.
The standard review is like most favorable to Commonwealth?
Standard of review most favorable to the Commonwealth.
What do you say the standard review is?
I think it's a substantial risk of miscarriage of justice.
No, but yeah, exactly. But how we look at the evidence? Do we look at it if the jury could have come up with the light most favorable to the Commonwealth or not?
I don't know. I never thought of that part because I was more focused on separate and distinct acts.
Sure.
But you know, it's let me address it this way: if there's a separate issue, if they find that it was a completed act and then not a complete act, then you get into then raise the question: was it proof beyond a reasonable doubt? Okay, what did he do? Jury apparently found, at least for one of those indictments, that he didn't murder her, and then they found he murdered her. And I think you have to look at this case in terms of is this a mutually exclusive verdicts? Can they be reconciled? And how this fits into the law, even the law of this Commonwealth.
Isn't Justice Gaziano's question important here? Because you could also look at it as, did one of the acts murder her versus one of the acts?
Sure,
not?
yes.
So
It seems like Judge Agostini used the light most favorable to the Commonwealth.
I don't know the answer to that. I didn't think about that. What I thought about was the fact, is there a miscarriage of justice, and how does this fit into the history of the law in the Commonwealth? In particular, I go back to the Haskins case and stealing and receiving. Okay, there's no they're irreconcilable. I mean, there are cases all over the country like this, and sometimes they're called repugnant verdicts down in Georgia. That's what they call them in Georgia. But the issue is, what do you do in circumstances like this?
I have a procedural question. So no sentence was imposed on the attempt conviction?
Yes.
What do we do with that?
I think that is very interesting, and the reason I focused on that, I didn't realize until, well, I knew about it when I did round one of this case, but what it suggests to me is that maybe the judge knew there was a problem here.
Well, I don't know that I'm going to go there, but I had a first question, which is, can you appeal a conviction that has no sentence imposed on it? Because I think we say, like, you can't appeal from a guilty filed. And my second question is, assume we were going to, I just have procedural questions, assume that we were to affirm the convictions here, what happens? Does it still remain with no sentence imposed on it? How does this, what happens here?
I don't know there's an answer to that. He certainly he appealed the convictions, okay? And he was convicted of attempted murder. So whether he was sentenced or not, is this guilty filed?
I don't know, but he wasn't.
Is it on the shelf, as they used to say when I did the trial stuff, trial work? I don't know. That's something that this court's going to have to address. But I do know one thing that I did research, which was in one of the original questions that came to the court, was, is there a double jeopardy bar? And I've researched that, and it's in my memo is in the record. There's no bar. He can be retried. I don't think there's a double jeopardy bar. And I went and I looked at it in the context of collateral. There's not a lot of law. I don't think there's any law in Massachusetts on whether there's a double jeopardy bar resulting from collateral when you have a collateral attack on the conviction. The only place it comes up that I've been able to find is in the habeas corpus area, where the collateral attack on the conviction stops the clock for habeas corpus. And I did address that in my memo because the court asked me to address it. But I would, in my remaining seconds, I would say that it is how do you explain this to the public, that he was, that complete, he did not complete the crime, and now he completed the crime? And that's what makes it irreconcilable. And unless the court has any further questions, I'll rest on my brief.
Thank you. All right, Attorney Von Fleeren.
Good morning, Chief Justice Spud, members of the court. The Commonwealth would ask that you affirm the denial of the defendant's motion to vacate and set aside inconsistent jury verdicts where the Commonwealth presented sufficient evidence on both of these indictments. It was this court that posed the question to the trial judge, or to the motion judge, who made findings in this case about the separate acts that support both indictments.
So we know it's a substantial risk analysis for unpreserved error, but is it a light most favorable to the Commonwealth?
I think that that's a neutral situation. Light most favorable to it looks like light most favorable to the Commonwealth, because the Commonwealth was saying there are separate acts and the defendant is saying that they are all
Because
one.
we have trial testimony and then we have the statement of the defendant, and it depends on how you twist look at them, right?
Yes, but when it comes to, I mean, it was up to the jury to determine if there was sufficient acts for attempt and there were sufficient acts for murder, and here they did find that. So I mean, I think that's what we're looking at, and I think that's the correct standard to apply.
Just help me out a little bit. So I take it the Commonwealth's point is, okay, they could have found he attempted to murder him by stomping on her and the pillow, but that didn't complete the act.
Well, and I think the stomping is not the same as smothering with a pillow, okay, and that was clear in the indictment.
Okay, then I get to the jury instructions, which don't divide out the acts, right?
Yes.
If one of the possibilities is the knife, that's a problem, right? Because then we don't know what the jury relied on to find the attempt, right? If the knife, it seems a problem if the knife which kills him is the same as the means of the attempt. Isn't that a problem because you can't sort through them?
Well, it's certainly less clear than the smothering, which I think is very clear, because the defendant has stated, and the indictment is clear as well, and Ms. Fisher has stated they attempted to smother me with these pillows. But I
get that you could separate them out. What
yes.
I'm wondering about is, given the way the jury is instructed here, is there a danger that you can't do that? We don't know what the jury relied on to separate it out, or do we not need to know that?
I don't think you need to know that. If they were instructed on, they weren't instructed that you must have them be separate, but they'd have to find in one case that it didn't complete the act, or it didn't complete the murder. There was an act that did not complete the murder, and then you have acts that did complete the murder. So I don't think.
I get it. It's just, again, this is sort of an academic thing, so I'm having trouble with it. But we really don't know whether what means the jury found for the attempt.
Yes.
If it's the knife, it seems like it's legally inconsistent. Yes. That's my problem.
Well, I think that the trial judge would agree with that, and the Commonwealth's position in our brief is that the indictment says by attempting to cut, and the statement of the defendant to the state police really parses out that he said, I cut with the knife and it got stuck and I took it out, and he kind of minimizes it somewhat, and then he goes on later to say that he stabbed Miss Fisher. But there was also a lot of him trying to cover for the co-defendant, and the co-defendant was also stabbing. So there was a difference there. But so I think that the jury could have parsed that out in the way that the defendant's statement, which was a lot of the evidence, came in. But I think that it is messy, and I think that with respect to the smothering, it is not.
If there had not been the erroneous jury instruction, how would this case come out?
If the instruction had been that, and left out that this was not completed, that the attempt could not result in the killing, then I think the attempt would be a lesser included and it would be dismissed, which was, in fact, basically what happened when there was no sentence on this. It wasn't dismissed outright, but I think the result was the same. This is not in the Commonwealth's brief, but just thinking about this, just recently there's the Commonwealth versus Nascimento that is cited in the defendant's brief, which just talks about when there is a situation where you have larceny and receiving stolen property that it used to be, well, that's so inconsistent, they both can't stand, and now there is a tendency to dismiss the receiving. So I sort of think that would be somewhat similar to this case. But again, we don't have a sentence on that attempted.
Did the jurors have before them, were the indictments placed before the jurors?
I believe so. They were read to the jury.
But they're not evidence, not part of
No.
the instructions.
No, I don't believe so. You're right. I think
Nor can they be.
right. The indictments, I think, went
They
to
go to the jury for a guideline, but they're not a substitute for legal instructions nor evidence.
yes, because we wouldn't consider the fact that they were indicted. But I think the indictments are most relevant to the fact that the defendant had notice of the Commonwealth's theories. If there are no further questions, I'm sorry, Your Honor. Okay. Commonwealth would rest on its brief. Thank you.